Donaldson on behalf of the appellants Patrick Malone and Blue Ridge Bank and Trust. This appeal is straightforward.
Do you want to reserve any?
Oh, I do, yes. 3 minutes, if you don't mind.
3 minutes.
Yes, please. Thank you. This appeal is straightforward. We call on the court to answer two questions. The first question is whether under Tennessee jurisprudence, particularly the Tennessee Supreme Court's opinion in Convalinka versus Chattanooga Hamilton County Hospital, whether that jurisprudence prohibits a trial court from holding a litigant in civil contempt where the litigant did not violate an express provision in a court order. That's the first question that we ask the court to answer. The second question that we ask the court to answer is if the court doesn't overturn the trial court's decision on that first issue, is whether the court's injunction that it entered on summary judgment violates the full faith and credit clause because it directly contradicts and nullifies an Idaho court final judgment. We're going to start with first whether the court erred in granting summary judgment in favor of the Roses on their claim for civil contempt. And we start with the statutes. Statute 16-1-103 basically gives the courts the power to enter civil contempt. And 29-9-102-3 provides that a court may impose civil contempt for the willful disobedience or resistance of any officer of such courts, party, juror, witness, or other person to any lawful writ, process, order, rule, decree, or command of such courts. And obviously the point of the statute, as Convalinka states, is to help courts maintain the integrity of Tennessee courts and the integrity of their orders. The Supreme Court in Convalinka definitively established 4 elements that a party must prove in order for there to be a finding of civil contempt. First, the order alleged to have been violated must be a lawful order. That's not an issue here. We don't challenge the court's order in this case. But then the second issue, and I think is the most important issue for the court to look at here, is the order alleged to have been violated must be clear, specific, and unambiguous. And the Tennessee Supreme Court in Convalinka spent a lot of time in that opinion discussing that, and we're going to discuss that this afternoon in the argument in full. And that's probably the determinative issue on this first issue that the court has to decide. The third factor is that the person alleged to have violated the order must actually have disobeyed or otherwise resisted the order. And then the fourth element that has to be satisfied is the person's violation of the order must be willful. So all 4 of those factors have to be met before a trial court can impose a judgment of civil contempt against a defendant. Here, second, third, and fourth elements are not met. Number one, there was no clear, specific, and unambiguous order prohibiting the conduct that Mr. Malone engaged in. And that is...
Okay, the trust, was the trust, the Tennessee trust, specifically approved by the Tennessee court?
The Tennessee trust was specifically approved by the Tennessee court,
The
yes.
trust terms say after listing assets that could go into it, and said further and additional amounts shall be contributed to the trust as may become available to Rosie. Isn't that pretty specific and clear?
That provision, Your Honor, I would say is fairly specific and clear, but the Tennessee court, the probate court, did not adopt or incorporate the trust by reference. It merely stated that the trust was in the manifest best interest of Rosie the child. And when the court entered that order...
It approved the trust, though, right?
Well, the court's language was that it was in the manifest best interest of the child. I don't think that the court actually specifically stated...
Didn't the trial court say the trust was irrevocable except that the trial court retained jurisdiction over it to modify it?
I think that's correct, Your Honor.
Sounds like the trial court's in charge of the trust to me.
Well, Your Honor, I would agree that the trial court, the probate court, and the guardianship proceeding maintain jurisdiction over that trust. But when we get to civil contempt is for violation of court orders. And that court order, when it approved the trust, if we want to use that language, it also provided that there were 5 specific sets of assets that had to be placed into the trust. And those 5 assets classes were very specific. I can go through them here, but it dealt with the retirement accounts, funds held in the court, an uncashed check that the guardian had from life insurance policy, additional life insurance proceeds, and any inheritance she receives from the estate. Those are the 5 assets that the court specifically ordered Mr. Malone to place into the trust. The court did not order that wrongful death proceeds be placed into that trust, nor did the court's order specifically have a catch-all provision that says that any asset coming to Rosie must be placed in the trust.
Well, that's pretty close to, what I read before is pretty darn close to a catch-all, isn't it? Further and additional amounts that shall be contributed to the trust as shall become available to Rosie.
Your Honor, yes, that is in the trust instrument. That is in the trust instrument, but that is not in the court's order.
Which the court approved.
That is correct, but it's not an order of the court. It's a provision of a trust. And the Roses did not bring a breach of trust claim. They brought a civil contempt claim.
Well, suppose we accept for the sake of argument that it's not violative, the creation of the trust, the Missouri trust, isn't violative of the Tennessee court's order. How was it not a violation of the Tennessee trust, given the language that Judge Bennett quoted?
Well, I would say that the Tennessee trust governs what the trustees are to do as trustees of that trust, right? It doesn't give instructions as to what Mr. Malone does, not as a trustee of that trust. And until that asset, the wrongful death proceeds, come into the trust, Mr. Malone and Pinnacle Bank as trustees of that trust do not have jurisdiction over that asset. So the trust can't dictate itself what Mr. Malone can or cannot do when he's not acting as a trustee of the trust.
Doesn't it?
You're not always a trustee? Aren't you always a trustee of the trust?
Yes, you're always a trustee of a trust, but you're not always acting on behalf of the trust.
Well, okay,
But
we won't banter words here.
But doesn't that provision place an affirmative duty on the trustee that when funds become available, they shall go into the Tennessee trust?
Your Honor, that's certainly a fair reading of the trust, but again, we're here on a civil contempt claim.
Well,
we're not here on a breach of trust
Your
claim.
argument was that the father had no duty to put these funds into the trust, and I was countering that statement.
I understand, Your Honor, and under the trust, there's an argument perhaps that there is a duty, but that's not what this case is about. This case is about civil contempt. This case is about whether or not Mr. Malone violated a court order willfully by taking the Idaho proceeds and asking that the Idaho court order that those proceeds be placed into the Missouri trust. And Convalinka is very clear. You have to satisfy all 4 of those elements. You have to satisfy the clear and unambiguous order. I think this argument, that order is not clear and unambiguous. If the court wanted or was ordering Mr. Malone to place the wrongful death proceeds into the trust, it could have ordered that. Because there was a disclosure in the petition to establish the trust, the wrongful death proceeds were mentioned. The wrongful death proceeds were mentioned as part of the petition. And despite the fact that it was mentioned, and despite the fact that the Roses had counsel at that time, and there was a hearing, despite all of that, the court ordered that those 5 assets be placed into the trust, but it didn't order that the wrongful death proceeds be placed into the trust. Now, Roses may argue, well, that's a future asset. We don't know whether it's going to come in for Rosie or not. But that argument is belied by the fact that 2 of the 5 assets that the court ordered be placed into the trust are also future uncertain assets of the trust. And that's any additional life insurance proceeds received from any insurance company, or any inheritance that Rosie receives from the estate. Those are uncertain, those are future, and the court saw fit to put those in the order, but did not order Mr. Malone to place the wrongful death proceeds.
So
in the
what's
trust.
is there a rationale other than trying to avoid the oversight of the Roses, the trust guardians, for creating a Missouri trust here? I mean, what's the implications
The
here?
primary impetus for that, Your Honor, was that Mr. Malone had moved to Missouri with Rosie, and the bank there that would be the co-trustee is the bank in his town where he and Rosie had moved.
Okay.
And so the element that even if Your Honors find that the trust provides that the wrongful death proceeds must be put in there, and therefore the order provides for that, I wasn't able to find a case where a court imposed civil contempt on a party for violating the terms of a trust or some other document that was approved by the court. It has to be a court order, and that's what Convalinka says. And number two, Mr. Malone can't have been found to have been willfully violating a court order because, number one, there is no court order. And number two, in Convalinka, the Supreme Court stated that the parties in that case could have reasonably believed that they were not under a court order to do what they were claimed to do. And likewise here, you can't look into the court's record and find an order that prohibits the conduct. And I'll just say before I sit down, even if the court does find that there was civil contempt here, the injunction that the court entered violates the full faith and credit clause because the Idaho court entered a judgment that required the wrongful death proceeds to be placed into and administered pursuant to the Missouri Trust.
Well, I was going to ask about that. It specified the Beatrice Malone irrevocable trust, but that's what the Tennessee Trust is called too, isn't it?
It is, but...
And the Missouri Trust hadn't been created yet.
Well, Your Honor,
right?
the Missouri Trust had been drafted. It just had not been signed.
And the court knew that?
The court knew
Iowa
that.
court knew that?
Yes, and
Then
I'll
why
say...
did the Iowa court not specify which one?
Well,
Which Tennessee or...
if in the petition that's in the record, and it's filed as part of the record, that petition never told the Idaho court what the name of the Tennessee Trust was. It said that there was a Tennessee Trust. It disclosed the fact that there was a guardianship here. It disclosed the fact that there was a Tennessee Trust. Nowhere in that petition did it name what the name of the Tennessee Trust was. The trust that was put forward before the Idaho court as part of Mr. Malone's petition, it had the same name. And so, and it had provisions in there, and it provided that the co-trustee would be Blue Ridge Bank, which is different than the Tennessee Trust. And so when the court entered the order requiring those proceeds to be placed into the Beatrice Malone Irrevocable Trust, it's the same name that's on the trust instrument that was before the
Do
court.
we have any, the transcripts of the Idaho hearings?
We do not. That does not.
So
part of the
we
record.
don't know if the name of the Tennessee Trust was mentioned during a hearing or not?
We do not know.
Okay, thank you.
All right, thank
Thank
you,
you.
Mr. Thorson. We'll hear from you on rebuttal. Mr. Switzer? Good afternoon.
Good afternoon. Jeff Schweitzer for Mr. and Mrs. Rose. They're named indispensable parties by the probate court in the guardianship estate. They're named limited trust protectors by the court in the Tennessee Trust we've been talking about. Obviously, the focus of Mr. and Mrs. Rose is the protection of Rosie's money while she's a minor and when she reaches the age of majority. Certainly, that's the focus of the probate court here. Unfortunately, Mr. Malone's focus is to use the money for himself, and that can be gleaned by looking at the differences between the Tennessee Trust and the Missouri Trust, which he drafted in secret. The Missouri Trust gives him wide discretion on how he can use the funds, and his discovery responses that are a part of the record show really what's happening here. he doesn't like the Tennessee trust, even though he agreed to it and the court ordered it. He doesn't like those terms. He thinks they're too restrictive, so he went off and formed his own trust in Missouri with far less restrictive terms, did not involve Mr. and Mrs. Rose as trust protectors, enabled him to essentially remove the corporate trustee, Blue Ridge, and not appoint anyone he wants to. It just gives him wide discretion. So that's really the root of what we're dealing with here is Mr. Malone wants to use this money for himself. He wants to buy things like cars, houses, and say those are for the benefit of Rosie. So importantly, the probate court assumed jurisdiction over the guardianship, over Mr. Malone as guardian, and the funds due Rosie in 2017 after Katie Malone died tragically in Idaho on vacation. Katie Malone is the daughter of my clients, Mr. and Ms. Rose, the mother of Rosie, and the ex-spouse of Mr. Malone. Now, the facts...
You said ex-spouse, were they divorced at the
Yes,
time? Okay.
yes. What's important here is the facts, and those facts are not in dispute. The law, frankly, is not in dispute, other than we contend the full faith and credit clause has no application here whatsoever, and I'll get to that. But the facts are very important. What we have, though, is Mr. Malone conveniently ignores some of the facts and doesn't emphasize those in his argument. The guardianship was established September 14 of 2017. March 7, 2018, he filed a motion for approval of attorney's fees and expenses for the fees and expenses his Tennessee attorneys were incurring in researching a possible wrongful death lawsuit. Now, whether it be in Tennessee or Idaho or wherever it might be, Mr. Malone was asking the court in Tennessee to pull money out of the Tennessee trust to pay the lawyers for researching the wrongful death case. March 15, 2018, the probate master ordered Mr. Malone shall immediately notify the court should he receive any asset in excess of $15,000 for Rosie and be placed on the first available docket to review the issue of bond. Immediately, tell the court if you get any asset.
And what order is that?
March 15, 2018, that was the probate master. And there was, of course, no mention of that in their argument. Quite obviously, that's a fact that's not in dispute, not addressed. June 7, 2018, Mr. Malone filed a sworn petition to invest the guardianship funds and establish a trust in the probate court in Tennessee. And he said, in part, the child may receive a substantial settlement or judgment from a wrongful death lawsuit as a result of her mother's accidental death. The petitioner, Mr. Malone, proposes transferring the guardianship funds to a trust under an agreement proposed on the attached Exhibit 1, the Beatrice Rose Malone Irrevocable Trust, with Pinnacle Bank and Mr. Malone as co-trustees. The petitioner believes the investment plan of Raymond James Pinnacle Bank attached to Exhibit 2 will be appropriate for the child, should be approved. So he swore to these statements, submitted it to the probate court, and says this is why we need a guardianship and a trust. He then signed and filed a corporate surety statement, June 20, 2018. This is all leading up to the filing of this Idaho case. He said he had a proposed trust arrangement with a corporate trustee, which is Pinnacle, as an alternative to a bonded guardianship, with a proposal that bond be waived. And he couldn't be bonded. He never was bonded. The trust enabled him to not be bonded and still proceed as the guardian. After there was much negotiation between my firm, it wasn't Mr. Thorson, but the previous attorney for Mr. Malone regarding this trust. We went back and forth, I think, for weeks, maybe even months, over the terms of this trust. We finally came to an agreement over those terms, and the court ordered the trust into existence. I'm not sure I understand their argument why this isn't part of the court order. The court ordered the trust into being. And the court said it's to be court supervised, the trust, pursuant to the order. That was July 19, 2018. And as Your Honor, Judge Bennett pointed out, it says Article 2, Section A, it shall initially be funded with the assets listed on Schedule A. Well, those were assets we knew about. Those were definite. We either liquidated or we knew what they were. This wrongful death case hadn't even, let's see, it hadn't been filed yet. There was some mention of it. They were doing research about it. We didn't know if they'd win, even if they did file it. So that's why we added the statement, and we agreed to it. Additional amounts shall be contributed to the trust as they become available to Rosie. That would include wrongful death case, any other funds that would come to Rosie. Again, the Tennessee Trust contains very specific restrictions on Mr. Malone's ability to spend this money. He doesn't like it. That's why he formed the Missouri Trust. So he filed this Idaho case in secret, by the way, October 23rd, 2018. We didn't know he'd filed the case, even though he was getting his Tennessee attorney's fees paid out of the Tennessee Trust for researching. He went off and found an attorney in Idaho, filed the case, didn't tell anybody here about it. He again sought approval of fees on October 23rd, 2018 from the Tennessee court. And he said, his attorney said in the briefing in connection with the second motion for fees, the court should consider that the child's estate will be or should be $2 million to $3 million or more, depending on the results of the wrongful death lawsuit and the litigation of the life insurance claims. So Mr. Malone, his attorneys, everybody's telling the court, we're gonna have this case and the money's gonna come to the Tennessee Trust. And the trust very specifically says any funds, additional amounts shall be contributed to the trust, and it was ordered by the court. There was a third batch of attorney's fees approved and awarded by the court for more legal research related to the wrongful death case. So he's wanting to pay his attorneys for researching this out of the Tennessee Trust and tell the court on one hand that I'm going to deposit the money, that on the other hand go out, get the money, and send it elsewhere. On May 20, 2019, this is after the Idaho case was filed, in the annual status report of the Guardian, Mr. Malone said, the Guardian submits that any wrongful death claim damages recovered from the pending lawsuit filed on behalf of Rosie as sole heir will be deposited to Rosie's trust established by the court at Pinnacle Bank. So this goes to certainly the willfulness. He knows, he's telling the court that I have this case, we filed it, I'm gonna get the money, I'm gonna put it in the Tennessee Trust.
Is that Guardian report in the record?
Yes, all these things
Yeah,
are.
what year was that report?
That was May 20, 2019, and I do
Okay.
have the record here, I think, let's see. 271 to 276, the record.
But, I mean, I keep getting back to the convolinka language. The order has to be clear, specific.
Yes.
And we're talking about an instrument approved by the court, not the court to order.
Ordered it, oh, sorry.
Yeah, I mean, you know, how do we get, I mean, what is the problem with saying, well, it wasn't a violation of the court's order, but you did violate your obligations as trustee in a trust and pursuing it that way? Why does that create an issue here? Why did it have to be for civil contempt? I appreciate civil contempt is more expedient, but, I mean, it seems like to me there's still a very live claim here of violation of the trust.
Well, frankly, we were in front of Judge Kennedy in the probate court when we learned about what Mr. Malone had done. And he seemed to believe it was a violation of his orders and restrained Mr. Malone from touching any of this money in light of what he did, and suggested, encouraged, perhaps suggested that I file a complaint for his violation of the orders, and that's what I did. So I guess maybe that's how we got where we are. It seems, and I don't mean to argue with you about it, but the court ordered the trust into existence and said this is a court supervised trust, and the document says all the money is to go, due Rosie is to go into the Pinnacle Bank. So yeah. I don't see the distinction between whether it's...
Well, I guess the distinction is what the court sort of alluded to in its order finding civil contempt here, is that well, yes, I didn't really incorporate the terms of the trust in the order. This is not a specific provision of my order. Yet I'm still going to say, well, we all sort of knew what was going to happen here. It seems to me that it's fair reading of the court's order on civil contempt.
I'm not quite sure about that, but what we do know is one person who knew what his obligations were, because he said it, and this is why I'm going through all these facts. I hate to read through facts. We know one person that knew what his obligations were. It was Mr. Malone. He said over and over, that's why I'm going through these facts here, over and over and over and over, I'm going to put the money in the Tennessee Trust. I'm adding the part, like you told me to do. that's my conjecture there. But that's what he said over and over and over. So there's no doubt in his mind where it's supposed to go. There was no doubt in my mind. We negotiated the terms of the trust. I don't know that there's any law on this point, but I would think when the probate court enters an order saying this trust, Exhibit A, is ordered by the court and approved by the court and is going to be administered by the court, I certainly think that's part of the court's order. I can't point you to something that says that exactly, but it certainly makes sense to me. Of course, that may not matter to the court, but nevertheless, let's see. So after we learned what he did with the money, which was well after the fact, we approached Judge Kennedy in the probate court, and he restrained Mr. Malone, and we ended up filing this complaint, an amended complaint. We ended up with a summary judgment motion, which was granted, and that's how we ended up here. One of the problems here, and I don't know that that's necessarily before the court right now, but in the first 2 years of having the money invested, Blue Ridge took it upon themselves to invest in all these risky assets and proceeded to lose $150,000 of the $750,000, which is one of the many problems here. Pinnacle had a very conservative strategy. The Tennessee Trust was very limited on how they could use the money. And Mr. Malone goes off with his own trust with a new bank, which was not approved by the Tennessee court, and they proceeded to lose quite a bit of money. Now, I don't know where the account stands today, frankly. I'm sure it came back some, but nevertheless. So the issues, and I'm running out of time here, but their main arguments are he didn't violate any orders. Well, I think it's very clear that he did. And even if he did, he didn't mean to. Well, the I didn't mean to part doesn't work because I've got all these facts in the record that I've cited in my brief and I've mentioned today where he's telling everybody, I know I'm supposed to put the money in there and I will, but he didn't do it. So that's his first argument. Second argument is the full faith and credit clause. I don't think that applies at all here, first of all, because Mr. Malone, I would contend, violated both courts' orders. The Idaho court said, put the money in the Tennessee, he said, put the money in the Beatrice Rose Malone Irrevocable Trust. That's what the Idaho court said. There was only one at the time the order was entered. There was one. It was the Tennessee Trust, which was formed by the probate court here.
And you think that's what the Idaho court intended by using that language?
I'm not sure what they intended, but I know there was only one at the time, so that's all it could have been. There's no way, I don't think, a court would ever order money to be placed in a trust that didn't exist. And that's been admitted today. It was admitted in their brief. It's an undisputed fact. November 12th, I believe, of 2019 is when that trust was signed. It doesn't matter when it was drafted. I mean, you can draft anything. When it's executed is when it means something. It wasn't executed till November 12th. These orders from Idaho predated the trust. So his guardianship status was obtained here. He was only legal guardian here, not from the Idaho court, not from Missouri. The trust was formed here. There was only one in existence at the time. So I believe I'm beyond my time.
All right. Thank you, Mr. Schweitzer.
Any questions, I'm happy to answer them. If not, I'll sit down.
Thank you, sir. All right, Mr. Thorson.
Thank you. I'll start with that last point. The Idaho court stated that the proceeds shall be placed into the Beatrice Malone Trust. Shall be. They didn't have the money yet. The trust was signed just a couple of days after the court entered its order, and then the proceeds were placed into the trust after it was signed. It happens all the time in trial courts that the trust is not actually signed until the court approves the terms of the trust. Doesn't do you any good to sign a trust and then the court make modifications when presented to the court. So yes, the Beatrice Malone Trust in Tennessee was the only one that had been signed, but the court's order in Idaho, we didn't have the proceeds yet. The trust was signed, the proceeds come in, complies with the order.
Did the Idaho court approve the Missouri trust?
The Idaho court had in front of it many of the provisions of the trust. It did not have the full trust, but it had who the trustees were going to be, what the terms of how the assets could or could not be used. And this notion that Mr. Malone's just going to use the assets in the Missouri trust to buy himself a car and a house, that's ridiculous. Under the terms of the trust, he had a co-trustee, and he was limited to make sure that those benefited Rosie. And I want to go to this language.
So did the Idaho court's order approving the settlement reflect anything that would definitively identify the Missouri trust as the trust it intended?
Other than the fact that it had the exact name of the Missouri trust that was presented to the court, and the court did not know the name of the Tennessee trust. That's what that evidence is. And I want to focus on this language from Convalinka because I think it's really important. Convalinka states that a person may not be held in civil contempt for violating an order unless the order expressly and precisely spells out the details of compliance in a way that will enable reasonable persons to know exactly what actions are required or forbidden. The probate court entered in its order said that the July 19th order did not explicitly require that the proceeds be placed into the trust, or didn't explicitly prohibit Mr. Malone from doing exactly what he did. And the Supreme Court went on to state that ambiguities in an order alleged to have been violated should be interpreted in favor of the person facing the contempt charge. And so where you don't have a court order that requires this conduct, it's at a minimum, it's ambiguous, and any ambiguities are decided in favor of the person who's being charged. Now, the last point I want to make is there was mention of the March 15, 2018 order that required disclosure. That was from the probate master early on, and that order stated pending further orders of the court. Then the July 19th, 2018 order comes afterwards, and it deals with the issues of bond and everything that the probate master had before it that those orders were subject to further orders of the court, and that July 19th order supplanted that.
All right. Thank you, Mr. Thorson and Mr. Schweitzer, for your arguments. We'll take this case under advisement.
Thank you.
Call the next case, please.
Michelle